On Radio 97, our resident lawyer Despina Priala of boutique law firm Priala Legal in Runaway Bay with us every Thursday to offer her legal expertise. And she certainly has plenty of that. She provides some general advice on the latest hot topics. She has experience spanning more than 25 years in areas of property and commercial law. She also has spent quite a deal of time preparing wills, including estate planning and litigation, etc. So she's got plenty of experience, and she's with us once again. Good morning to you, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. So, a little something thrown in there. You actually specialised in preparing and creating wills for people for a long time. So can you tell us a bit about that?
I have. So I know that we focus a lot on property and commercial, which I love. And I've done that for many, many years. But I also have done wills and estate planning for clients over the years, since the 1990s actually. So I guess I'm showing my age a little bit. But yes, I've done that for many clients over the years and love it. And estate litigation is a passion of mine as well. So people either making claims against an estate, or if there is an estate and you're looking after executors to manage it, and the executors will then have to defend those claims.
Sure.
So that's part of what I've done over the years and continue to do for clients, and absolutely love it, as well as property.
Hey, can I ask you right off the top, are there many people that you've come across over the years who don't have a will?
Many people. It's a common theme. It's been like this since I was in practice in the early 1990s, and it's still the same today. And I can't really put my finger on it, other than I think there's this idea that if you start to talk about your will and you start to go down that path of let's do a will, then you have to talk about things like, well, yes, you're going to die at some point. We all are going to die at some point. And then you have to think about those things that maybe you don't want to think about your family that you're going to leave behind, what's going to happen to your estate. It's a bit confronting. But I say to people, let's tackle it, head on. Let's deal with it in a positive way. And then what you have, the outcome of it is that you've got an estate plan, and it's a good estate plan, and it's in place, and you've looked after your family because you've spent years, building up assets, building up a portfolio, and you want that to be managed in the right way and distributed in the right way when you pass away.
Yeah, and obviously since the 90s when you started doing them, things have changed. Technology has changed, and we've seen some really interesting cases in regards to wills and how they're dealt in the courts. So can you shed some light as to what's changed, I guess, in the past 20 years?
Yes, well, as everyone probably is aware and should know, when you want to make a will, it's got to be in written form. So that's been from day dot, and it's under each state legislation in Australia and in the Succession Act predominantly, and it talks about how do you make a will. It's got to be a written document that shows what your testamentary intentions are, and it's got to be done by a solicitor, because there's a way that a will has to be prepared in written form that makes sure that it shows what your intentions are, your testamentary intentions. It's got to be worded in a particular way, and it's got to be taken care of where your assets are distributed in a way that's valid and that's binding. And of course, you've got other things such as who's going to be your executor, who's going to take on that role, who's going to manage my estate. And of course, other things that are thrown in, for example, particular wishes. If you want to be cremated, if you want to be buried. There are a whole range of things. So with the age of technology that we've encountered in the last, 20 years, 10, 20 years, but just most recently, say in the last 5, 6 years, we've seen some interesting things through the courts. So, as I said, traditionally it's got to be a written document. You've got to sign it as the person that's making the will, and you've got to do it in front of 2 independent witnesses. Okay? So that's generally the hard and fast rule. But what we've seen recently, and I'm talking the last 5 to 6 years, is we've actually seen some interesting cases that have come forward. And as I've said before, every time you go to court, each case is assessed on its individual merits. So when I talk about these cases, it doesn't mean we're opening up Pandora's box where everybody will be able to do what I'm about to talk about, and then it'll be deemed valid. So I'm talking about video wills, and I'm talking about text messages being identified as a will.
That's an interesting development.
And this is something that people read obviously in the news as well, and that would just cause a bit of confusion, immediately being like, oh my gosh, well, I just did my will. What a waste if I could send a text.
I'll just send a text, there you go. Yeah.
Could have saved me some time. So obviously, yes, like you're mentioning here, it's very specific situation. So what were they?
Well, I'll talk about the cases, but as you said, it's quite easy for people to take that message away, isn't it? Because everybody texts, everybody's on social media, everybody loves
a napkin
texting.
and a pen or a video, whatever.
Exactly. So they go, this is free. I'll just text away a message. I don't have to see a solicitor. I don't have to go to the hassle. I don't have to be in this confrontational, perhaps, situation where they don't want to talk about, but they really do need to talk about their family, their assets, and what they want to have happen when they pass away. So unusual cases, but there was a case a few years ago in Brisbane where a man committed suicide. So what he had done is he did not send a text message, he had written a text message, and it remained unsent. And it was addressed to his brother. Now, obviously, when they found him, they're obviously able to open the phone and see that there was this message, and it was unsent. And it was taken to the courts because the person did not have a written will prior, or if they did, it wasn't deemed to be valid. And they had to look at this text message and determine, is this a will or was it a will? Can it be classed as a will where it will be deemed to be valid? And that means that the courts and other people will have to comply with what is in the written text message. And in this case, they found that it was valid in that it was deemed to be a will, even though it was unsent, even though it was a text message only. So no written document, no independent witnesses surrounding this person, obviously at the time he committed suicide, and he did that prior to the act happening.
So there was enough information in the text for the court to say, yes, we believe that this is what this gentleman wanted as his final thoughts.
Yes, well, like I said, let's look at the individual facts of the case, because not every text message is going to be classed as a will. So that's the message I want to get across
You know what's so funny?
to the listeners.
As you're saying this, I'm guilty of this, which is so bad. Not as obviously a legitimate will, but I remember messaging my sister going, it was when I heard about this natural burial ground thing, and I said, this sounds like a fantastic idea where you can get buried without a coffin, yada yada. And I messaged my sister going, hey, I want to be buried in a natural burial ground. Can you just remind mum and dad, which sounded awful, and she had a joke and that was it. But like things like that where you legitimately have this thought and actually put it in text. And what if that's the only statement that you have in regards to leaving?
Yeah, look, it's a good point that you raise, and I think we can easily deal with that with when we talk about this case versus let's just send some text messages randomly at different times of the day, week, years to my family. Oh, by the way, this is what I want to have happen.
Or
so just remember that.
My so-and-so when I'm gone. Yeah.
Exactly. So in this case, why the court deemed it to be a will, there's a few reasons. So when he sent the text message, he actually labelled it as his will.
He stated that from the top. Okay.
That's right. So when we go back, and it makes sense, doesn't it? It's logical, because when we talk about a will, it's got to be in written form. And in the written form, it always starts off with, this is my last will and testament. So it makes it very clear what this document is. So he labelled his text message as, this is my will. Okay, so of course he was thinking with his right mind by writing these messages in the way he did. He put his initials and date of birth at the end of the text message. So that was another good thing, obviously, for him in this case and his family in the situation. So when you do a written form, you start off with, this is the last will and testament of me, Joe Smith, for example, and you always must sign the will and your name and your signature, and you must date it.
Okay.
So he's followed that, if you could say that, in the text message. Rather than saying, my house goes to Bob Jane and my superannuation goes to this person. Well, do you really mean this to be your last will, or are you just throwing out their ideas? Which is quite different to making sure that the purpose of this text message, if you have to be in that situation, which you wouldn't want to be and it's not preferred, is, okay, the idea is this is going to be my last will. These are my testamentary intentions, and this is what I want to have happen. And you put your name and your date of birth and various other personal details. So that is why, or that's one of the few reasons why the court in this case, it was a Queensland Supreme Court, why they deemed this text message to be a valid will, even though it wasn't sent.
And as you say, the court said yes, this was valid, but it's certainly, by the sound of it, not something you would suggest as a good idea.
No, because in the court, I remember reading it, this particular case, when it came out, and there was an argument by other people from other family members that said, yes, but if it was intended to be a will, it wasn't sent. So maybe he was going to change his mind. Maybe he rethought. But then the circumstances of the suicide really had the court say, well, no, he definitely deemed it to be because of the events that transpired. And there was no other evidence to indicate otherwise. He just forgot to send, or thought he had sent and didn't. So when you send messages, sometimes you thought you've sent the message on your phone.
I'm so sorry, I didn't hit send. We send it all the time.
That's
100%.
right, exactly. So that's some of the things that have evolved over the years, and of course, video wills is another one.
Yeah. And of course, we've seen what's happened in terms of video over the last 18 months, 2 years. Businesses have changed, and we've certainly changed the way we communicate. And video wills, I guess, is one possibility as well.
It's a possibility, yes, that you can do a video will, but I have to say that it should be approached with caution. So I always will say do a written will, because that's what the law requires. So we don't want to start deviating all the time from what the law says so much. But if you wanted to do a video will, there is nothing wrong, in my view, with doing a video will with a written will.
Yes.
So they work together. Okay, so like I was talking about the memorandum of wishes a few weeks ago, which is another written document to go with your will to explain why you have said certain things in your will or have excluded certain people.
Yes, yeah.
And that speaks for you from the grave. So it's nothing better, I think, than having a written document speak for you after you're gone, as opposed to other means. But in terms of a video recording, which you do yourself, maybe with your solicitor, maybe it's via Zoom, maybe it's via Teams, maybe it's then recorded and we talk about the testamentary intentions, then maybe a video will can be seen to be a deliberate oral statement of your testamentary intentions.
Yeah, for sure. Well, we are speaking about wills today on Talking Law, and coming up next, what happens if you want someone to talk on your behalf once you're gone? Coming up on Talking Law, you're listening to Radio 97.